Dumelang.
Vamos mulai gitu.
All right, ladies and gentlemen, good morning. Let's please take our position so that we can start. Let us please take our position so that we can start. Our speakers are here and the media is here, so right. With the room now in order. Good morning. We have called you in here this morning, and I'm going to do very quick introductions. With us here, we have the president of the Alliance for Progressives, Mr. Ndaba Gaolathe. We also then have, just to my right, an honorable member of parliament for Jwaneng Mabutsane, Mephato Reatile. And then we have to the president's right, Honorable MP for Okavango, Kapinga. The gentleman here represents the contracting parties in the opposition, and our subject matter today is a bill that has brought so much consternation, the Criminal Procedure Evidence Bill that supposedly is going to be brought for Parliament, and that has been given a certificate of urgency for debate. We are not going to take too much time. The President will lay a foundation for the discussion, the philosophical aspect of the bill. And then MP Kapinga will speak to the national security implications of the bill. And MP Reatile will close with the political and other implications of this bill. Without much further ado, I will request President Ndaba to make his opening remarks. Thank you.
Good morning, everyone.
Good morning.
It's good to see all of you. Ladies and gentlemen, we're here to ponder on a bill, this Criminal Procedure and Evidence Bill that is currently before Parliament, and one that claims potency against crime and criminals. This bill is the clearest sign yet that this country is descending into authoritarianism under the current government. We understand that this bill has been or is being held in abeyance, but its very idea deserves our strongest resistance. Think about this. A young, talented citizen harbors private ambitions to become a global music megastar and is shy to disclose this to family or to a circle of friends or even a society that can at times be so judgmental and harsh on those who dare dream big. Such budding talents don't conform and are not compliant with the narrow expectations of society. Such budding talent craves privacy and private space to sing in the shower, to explore, to experiment, and to be creative, away from the judgmental and watchful eye of family, community, and even government. It does not have to be budding music talents. human beings in general by instinct cherish private spaces within which they can develop, within which they can explore, within which they can experiment, within which they can become the best versions of themselves without anyone snooping and casting judgment over them. This is called privacy, and it is intertwined with the very meaning of freedom, without which individuals, communities, and societies cannot achieve genuine happiness, nor can they reach the best version of themselves. This is why humanity, through generations, through history, in every part of the world has cherished and continues to cherish freedom and privacy. Privacy and freedom are gifts which no one, not even government, should have the right to take away or steal from the children of the land. Privacy and freedom are at the very core of what it means to be an open and democratic nation. In the modern era, handing over your privacy rights to the government and the rogue institution that is the DIS by allowing them to intercept your telecommunications at will is akin to handing them over the keys to your phone, the passwords to your bank accounts, the keys to your private spaces. Those who say they have nothing to hide and therefore nothing to worry about this would never hand their passwords and keys to their own family members. Never. They would never do that, because it is not about having anything to hide. It is about claiming quiet spaces for yourselves, quiet spaces in which to be creative, explorative, and in that way developing to be the individual that you wish to be. This law seeks to take away this fundamental right. It seeks to rid the children of this land of the quiet places that they can call their own. This law seeks to stunt the personal growth of the people of this land. This bill will take away the core fabric that brings out the best in human beings and brings happiness to them. This law looks for all sorts of excuses to bypass the role of the judiciary and grant the executive branch of government a blank surveillance check over the entire population, even those that they know are not criminals. Worse than the law itself is the idea of the law, intended to instill fear in the minds of ordinary people. The real intent of such a law is what is called psychological imprisonment of the people, a condition in which people believe they are being watched, even if they are not. This is a technique that is used in prisons and in dictatorships to ensure that everyone behaves in ways that are compliant and conformist to the assumed wishes of the authorities. In many cases, it is a means to intimidate those who differ with government. Those who differ with the government of the day, including political activists, journalists, and others who are not compliant or conformist in the eyes of the regime. Every nation needs its activists. Every nation needs its journalists. Every nation needs its creative, non-conformist segments for the larger collective good, even as others may not immediately appreciate this. Of course, we know that no democracy is perfect, and privacy can be tempered. But that is why we have and should have a fair system with a strong judiciary, a judiciary as a branch of government. The idea of an independent judiciary is so it can provide checks and balances against the excesses of the executive branch of government especially. This is how a genuinely democratic nation that understands that the true power is with the people works. Freedom, our freedom, is part of what unites and makes us happy as a people. You know, many jurisdictions actually do have laws against criminals and criminal activity, but they ensure that there are limits. For example, some jurisdictions ensure that those that are being put under surveillance are notified exactly so that they can resort to remedies if needed. Most jurisdictions ensure that absolutely investigating authorities have to go through the judiciary, because that is the only way that we can ensure that there is fairness. Freedom, privacy is what every nation that wants to bring out the best out of its people pursues. Freedom is what unites us. Freedom is what gives our children, our uncles, our parents, our grandparents, the space to be creative, the space to explore, the space to become themselves. We cannot and must not allow that to be taken away. We must not allow that which has been God-given to be taken away by this or any other government. It is our responsibility, it is our moral obligation to ensure as citizens, not as political parties, as citizens, we need to stand up and ensure that this country keeps its freedoms so that we build a future for our children. After all, our vision, the vision of all of us, should always be to create a world that we can be proud, that generations that come after us can be proud. I'm going to hand over to Honorable Member of Parliament, Kapinga, to continue and give us aspects, particularly of the regulatory theme.
Thank you very much, Mr. President. Dumela Marajo. I need to introduce a little bit of myself so that you understand the perspective from which I'm coming. Some of you may remember that I was in law enforcement for many years, 28 years. And I left law enforcement at the level of Deputy Commissioner responsible for operations. In addition to that, I am a qualified lawyer, and I'm going to speak on the issue of regulation and accountability. I need to emphasize that privacy is a fundamental right of every individual that needs to be respected, even by law enforcement, even by our security apparatus. That needs to be understood. It's not negotiable. That privacy is a fundamental right of an individual under our Constitution. So, the point I'm going to make is that we need to understand that there are some legal, there are some statutes, or there are some countries that have put in place laws similar or akin to ours. But there is a great ocean of a difference in the way that they have approached this issue. In the sense that when they came out with a similar kind of law, they put in place very strong regulatory authorization and accountability requirements. I have picked the example of the United Kingdom, where they have the Investigatory Powers Commissioner's Office. This is an office, a very independent office, not the kind of independence that we talk about in Botswana, because like I've said in Parliament, Botswana remains a primitive democracy. I'm talking about an institution that is really independent in its operations, the Independent Investigatory Powers Commissioner's Office. What do? They independently oversee the use of investigatory powers. If I go back a little bit, when I was in the Botswana Police, I was assigned to be part of the team that negotiated what is now called the Palermo Convention, the United Nations Convention on Transnational Organized Crime in Vienna. And it was signed in Palermo, 2003. Botswana is a signatory to that convention, the Palermo Convention. We have signed and ratified that convention. And Article 23 thereof required states to put in place electronic surveillance measures to address transnational organized crime. I have to put that in brackets. To address transnational organized crime. So these laws are meant to address specific national threats against the country. At that time, the biggest threat that faced the world was transnational organized crime. Then in 2011, September 11 happened. That's when the whole world now opened its eyes and focused a lot of attention on combating terrorism. And as a result, many countries came in, passed laws that were meant to facilitate their security organs to address terrorism, the terrorism threat. But civilized democracies put in place institutions such as the one that I have referred to, the Independent Powers, Investigatory Powers Commissioner's Office, to independently oversee the use of these intrusive investigatory powers, to ensure, and mark these words, to ensure that they are used in accordance with the law and in the public interest. In accordance with the law and in the public interest. In 2013, there were high-profile allegations in the United Kingdom which drew widespread media attention and raised public concern over use of investigatory powers. What did the government do? They assigned a high-profile individual, an eminent citizen, to investigate the whole issue and submit a report to the government, the Prime Minister. He's called Lord Anderson. And the title of his report was A Question of Trust. A question of trust. And that's the same issue that we are raising today when we look at the legislation that has been presented by our government. Is this a government that we can trust with this kind of legislation? And our answer is unequivocal, that this government is untrustworthy, especially with this kind of legislation that intrudes greatly into the privacy of individuals. What were the recommendations of Lord Anderson? His recommendations was that there should be legislation. He recommended legislation that would ensure privacy of communications. In order to underscore that right that you are given under the Constitution, there should be legislation that emphasizes that your communication is private. You also say the legislation should prohibit interference by public authorities unless on specified terms. You get me? Not generally. Not to give our institutions, our security institutions, a blank check to invade your privacy. There should be specific terms under which they can do what they wish to do. And the law should also provide for judicial supervision, judicial authorization. The judiciary should authorize the use of these intrusive investigatory powers. There should also be a regulatory mechanism, and that regulatory mechanism that was put in place is the Investigatory Powers Commissioner's Office. They are the ones that regulate the use of these powers to ensure that the security service or those institutions that are authorized to use these investigative procedures adhere to the requirements of the law and do all these in the national interest of protecting national security and nothing else. Another thing is that of parliamentary oversight. In this, our democracy, which I call a primitive democracy, the right of parliament to oversee some of these institutions, especially when it comes to security matters, is undermined by the executive. The executive is also always of the thinking that they are the ones who should enjoy the privilege and the authority to supervise what our security agencies do, and that parliamentary oversight committees are nothing but a mere nuisance and interference. So this is a government. This government is not a government that we can entrust with these kind of powers, which does not recognize the full authority of Parliament to oversee these issues. So this report by this gentleman led to the promulgation of the Investigatory Powers Act of 2016 and the creation of the Investigatory Powers Commissioner. And the big issue in that legislation is safeguards, putting in place safeguards to ensure that these laws, these procedures are not abused and used to settle political scores against one's adversaries, like we have seen in the recent past with the use of the DIS. So, for this law to become, less repugnant to us, it needs to address the culture of impunity that we see in this country, where the government can violate the rights, the fundamental rights of an individual, and no consequences follow. What would rather follow is to try and, close the individual that was involved with immunity, so that they don't suffer any consequences for the wrong doing. We want a situation where these things are strictly controlled, strictly regulated, and where you need to be given authority first by an independent institution such as the judiciary to resort to that kind of investigation. And we want to see a situation whereby where you have violated the law, where you have used these measures for none other than in the national interest, there must be consequences that follow. Not only for you as the operative DIS, police, but also for the government for which you were acting. So that's our position, ladies and gentlemen. Our position is not that these laws are totally unimaginable. They are there in other countries. Our position is that we need to accept that already our phones are being tapped. If you didn't know, you should know, by our security apparatus. So this law was meant to, assist the Republic of Botswana in terms of its assessment by the Financial Action Task Force. Do you have laws that regulate the use of intrusive investigatory powers? So now they came rushing with this. And our biggest objection is to come with this kind of law on a certificate of agency without having first laid bare before the nation, for this is what we want to do. These are the reasons why we have to do this. And this is how you are going to be protected as a citizen of this country from these intrusive investigatory powers. That failure to follow this process and to leapfrog from here to the other side is what makes us to believe that this is totally unacceptable, and they have to go back with this legislation and go back to the drawing board, as people say. I think that's what I wanted to share with you for this morning, and I'll wait for any questions that may arise. Thank you very much, Mr. President.
Thank you, Comrade President. Ndaba Gaolathe. I'm going to deal with the political implication of this road law. We are here because of BDP has reached the stage of political decay. That is a fact. And maybe before I talk to this political implication, I have to say, to address on what Honorable Kapinga has alluded to, the genesis of counter-terrorism started in 28th of September 2011, after the September 11, is when we came up with the first resolution, which is commonly known as Resolution 1373. And in that resolution, it was encouraging the government to work hand in hand with other member states to share the information. But what happened to Botswana, even though the resolution is binding Botswana to make sure that we're going to comply with that resolution? Here we have that butterfly. Butterfly. She was a terrorist, according to our government. But they have never shared or reported that case to the United Nations, according to the resolution 1373, because they know that no, they were only tarnishing her name, destroying her career internationally. So after that resolution, there were a series of resolutions came, Resolution 1535, Resolution 1624, Resolution 2178. But we have to understand one thing here. We are dealing with a government that really focuses mainly in Botswana, to make sure that the lawyers, journalists, politicians, unionists, they're going to face the music because of this law. You have to know that some of you, the phones have long been stolen by the agent of the DIS, and they have managed to use the digital forensic tool to extract the files from your laptops. The information is there. All what they need is to make sure that this law can pass, and then you're going to face the music of your long stolen gadget of your being the laptop or the cell phone. So this real is going to happen to your doorstep. So when you're talking about the fake IDs of this law, let's say the 300 people of the trusted people in the security organs, they're going to, each of them is going to use 5 IDs because they say that IDs, it will be authentic, just as some of them, they will be for the people who have long died, but you cannot challenge this. No, this one, because my elder brother, I had buried him 5 years back. You're going to face the music. The prison will be waiting for you if you can disclose that kind of information. So that 300 people, if they go, each of them, they can use a 5 ID, each of them. It's going to be 7,500 votes. And that you say 1,500 votes times 5 is going to be 7,500, which means during the elections, and if the election is going to be led by those people who normally participate as the officials, those who vote before us, you know, each and every constituency, BDP, they will be in a comfort zone, saying that no, we are leading by 7.5. We are leading in each constituency by 7.5. But here's a coincidence. We are coming up with this law, and at the same time, they have managed to delay the population census. So it's going to coincide this fake ID with the population census. So you cannot segregate to say no. The population census, it says we are so many in our country, because it's going to, they're going to measure it. They're going to synchronize the fake numbers with the original figures from the population census. So you cannot segregate which one is fake and which is the original, because it's going to come up in a very same day when they say we are 4 million in Botswana, because they know 500,000 of that 4 million is a fake ID. It's going to be like that. And I was reading somewhere where they said the press secretary to the president, he failed to comment because he said when he was asked a question, he said, no, I cannot comment because the law is not under our ministry, is not under the presidency, it's from a different ministry, and the Ministry of Security, blah, blah. Yes, the law that we are referring to is under 𝐉𝐎𝐈𝐍𝐓, but in our culture, when each and every bill come to before Parliament, it's come from Cabinet, it's been discussed. But the unfortunate part of this one, it has never been discussed before Cabinet, never. So the other bills, they were discussed, but this one is one of the rare species. It has never been discussed before Parliament, before Cabinet. It's only those who are supported it to came under certificate of urgency. Even at Cabinet, they have never put a hand on it, because whatever is happening in our Cabinet, you always know better than us, because you are interconnected. That's why they want to take off your feathers so that you won't fly. And the other thing that I wanted to deal with it here is, maybe the question can be, our role is to debate this law in Parliament. And we're going to explore all avenues to make sure that we try to shape this law to a better law. If the law passes in Parliament, we have to find the legal brains to see whether we can approach the court of law, because it's against the Act versus the Constitution. The right that we are given by the Constitution cannot be overridden by a certain Act of Parliament. So we will need the interpretation of the bench at CBD to see whether the law is well crafted or not. And at the same time, it's entirely upon the civil societies to make sure that they stand up on their own to make sure that their freedom is under siege because of this law. Those are the things that really we're going to make sure that we cannot let it, because where we are, you cannot approach a court of law, because court of law cannot interfere with the role of parliament, because we are operating in a three arms of governance. But once you have, the parliament has exhausted all the stages of making laws, now an individual can approach the court of law to say, no, I want to understand whether this law is well crafted according to our constitution. Then is when the legal brains, they can come up with section after section, section after section, to make sure that we are trying to dig deep whether our law that we are really concerned about is in line with the best practice, international best practice. But when we are dealing with law, this kind of law, there's another organization called 𝐒𝐏𝐻. 𝐒𝐏𝐻 is Geneva Center for Security Sector. It's overseeing all the security apparatus internationally. So we went to Geneva some time back. When we met with the 𝐒𝐏𝐻 officials, they said, no, there's nothing that is classified as sensitive information under the people who are applying oversight, like the committee which will be doing oversight here under the DIS. In Australia, they have managed to put up that committee. If you approach that committee, say, no, I suspect my phone has been tapped. That committee will go to the DIS control room to go and check whether indeed the applications that are before court are only the ones which are monitored in the control room. But in our countries, as Honorable Kapinga has already indicated, really there's no one who is willing to make sure that the role of oversight is going to be applied in this country. Now we have the cabinet, which they have turned themselves to junior angels in our country, to make sure that whatever they are saying is in line, whatever they are dreaming is correct, whatever they are feeling is in order. So we have to make sure that this is not in line with the international best practice anywhere on earth. So that's why we are calling this press conference to come and share with you, to say, ladies and gentlemen, we have to make sure that we stand up for our own rights. There's no one who will come from England or from UK, from US to come and say, no, do the following. We have to stand up for our own rights. Honorable Chairperson, let me stop here.
All right. Thank you so much to the speakers. I think by now it's very clear. The contracting parties in the offices are not saying we should let criminals and terrorists roam unchecked. They're basically saying we can enact legislation that ensures that the country is protected, that ensures that we combat money laundering and terrorism, but we can do it without taking your rights and civil liberties as citizens away. And the key thing that also came out is that you cannot trust this government. And if you cannot trust them with just about anything, you can't trust them with your critical information as a private citizen, communication between you and your wife or your girlfriend, communication between you and your sources as journalists, communication between you as a business person and your partners. You can't trust the government. And because they cannot be trusted, we need oversight mechanisms. We are not saying this country should be a den of criminals. We are saying it can be done without taking away from our citizens. We will open for comments and questions, and then the speakers can respond to those. When you ask a question, please just mention your name and media house, and then show it. Thank you. Done.
molao o eletsa o boetse ko morago. Then gore a letse le e nngwe ya bobedi a letse le jale ga le bone ba go BDP mme re ntse re le la re tla ba tla botswana gore ga gona madi a le bone ga ba se ba le bone gore this exercise ba batlang go e dira budget ya teng e ya go tswa kae le yone e tla e go kae ka ra dira gore ga o bua tsone dipalo tsa bo 7.5 batho ba direlwa di-ID ke madi a mangwe a mantsi ga go thekwa le go batlega di-equipment tse dingwe gape ke batla go ntse le gone go.
Thank you, Mr. Chida. Any other question? All right, I think, okay.
Online. One, there's a comment here that says opposition Ratagolela. Maybe you can respond to that. I'm Ratagolela, as they say. And then this one would go to you, Kapinga. As an advocate, it means you have had chances to this warrant of arrest, before the magistrate. I want to understand, because part of the clause talks about the 14 days. Without my knowledge in the 14 days. And then after, one can then go and apply at the magistrate. My question to you is, one, when one is applying for these warrants, can it be rejected or can it not be rejected? And then two, if at all, whatever it is that they were looking for, within the 14 days, my 14 days has lapsed, and what it is that they wanted, they did not see or did not find, what then happens? What can I do as a citizen to ensure that my privacy, at least from that point, it's then protected?
All right, thank you, Mashomba. All right, I think after the introductions have been done, we had Secretary General at the DPP, Meno Nochafela Mokoke, coming in, and let me just recognize their presence, and then also the presence of the BCP Publicity Secretary, Professor Mopeko.
Morning.
Right, so while waiting for the next few questions, let's go into answering the ones that have been asked already. Reggie and President Ndaba, the first question I think one of you can attend to, then the next one is specific to Kapinga.
Thank you, Boris. The question is very short and clear. Whether this thing has ever happened in the history of Botswana to take the government to task against a certain piece of legislation, the answer is no, as far as I can remember. But everything has a beginning. I believe we have to make sure that if this thing has never been happened before, became more active in politics, it will happen this time around. On the issue of budget, you are better placed to know that there's no money in the country. The projects are not operational. We are getting the loan every month, every session, every meeting is a loan after loan, which means we don't have money to fund this kind of heavy technology that we're going to be introducing in our country. But Honorable Gaolathe, Honorable Kapinga, they will buttress in what I have already said.
Yes. Mr. Chida, on the question of whether it has happened before, there are two parts to that. He's answered the first part. There's no recollection of it happening post it becoming a law, being signed and being called a law. But in terms of a prospective law withdrawn, there have been cases in the past, such as the intended privatization of the Air Botswana, for example, is one of those bills that was withdrawn midstream because there was an outcry. Budgets. Well, budgets are always about priority. Any nation that wants to develop, every nation that wants to modernize, every nation that wants to become exemplar has to ensure that it prioritizes better than everyone else. And if you asked us if some of these things, a blanket, an infrastructure to facilitate such a blanket law is not a good way of prioritizing our small resources. And that's for sure.
All right, thank you, Ndaba. There's before Kapinga, maybe you could just speak to the comment that says there's opposition about our layer, and then he can come in.
Oh,
yeah, would you like to speak to that? Yeah.
Oh, okay. Well, I think part of it is true. It is true that opposition in general does have a culture of being alarmist. But it does not mean that because there is a culture in opposition of being alarmist, it does not mean that we do not have enough of a threshold, enough good men and good women. Let me tell you, for every society to prosper, you don't need everyone to be good and entrepreneurial. You need a few good men and good women to ensure that there's prosperity. In any church, not everyone in every church is an angel. You need good people, a few good men and a few good women in the church to ensure that the church manages its vision. In any government, no matter how good, it is not having many good people in government. It is always about having enough good people to ensure that we move on to where we ought to be. And I can assure you that within the opposition, there are enough good men and good women who love this country, who are sacrificing themselves, and if given a chance, they will ensure that this country transforms to become an exemplar on the African continent. And that is for sure. For sure. Do we have good men and good women? We have good men and good women, enough of them to transform this Botswana to become a great nation.
Thank you, Honorable Kapinga.
Thank you, Comrade. In Shona they have a saying, Kuraone, Kastana had to call our board. So how to cover the opposition and Rataholela? Nine upon Tower, Aisa, Olison, Aisa Bonigi, Taranagomadi Boli at Talokante, Dimamile, Mahua, Oda, Hopola, the opposition Rataholela. My responsibility is to answer the question relating to whether an application for a warrant can be rejected. Yes, it can be rejected. And we saw that recently in the case involving the DIS and the former president. There was an application for a warrant to search, which was rejected by Justice Busam, because the applicant in an application for a warrant needs to be very candid with the court and disclose all the critical and material reasons why they believe they have to be granted a warrant to invade the rights of a citizen. So they go before the court and they do not disclose fully why they would want to listen to your phone, why they would have to intrude into your laptop, the court is within its rights to reject that application. 14 days unauthorized tapping. The law currently authorizes the security agents, if it were to be passed, It would authorize the security agents to, intercept your communications for 14 days without warrant. If you never got to know or they were intercepting your phone, you would never do anything about it because you wouldn't know. So you can only do something if you get to know that they have been listening to your phone. They make sure you don't get to know. So they will listen to your phone. If this law were to go through, they will listen to your phone and you won't do anything about it. Our position that we believe is that if it is such an emergency and you are dealing with the right circumstances, terrorism, money laundering, transnational organized crime, within 48 hours, you should present yourself before the judicial officer to authorize any continued interception of the communication of the subject under investigation. We don't agree completely with a 2-week blank check for our security agencies to listen into people's phones. We believe that there should be checks in the form of judicial authorization. Thank you.
Thank you. Before we take another round of questions, Reatile, you wanted to throw something?
Minister, declare a terrorist minister. However, kana ro tlharela a ile go kwadile o ke go santsa se ka khanyo ke lengwa wa mo kwa 7 years back o itse ra go tota wena you a terrorist ka rona kwa hamala ya is na go heta at any given time o ta ba go declare gore mme ga di khangwa gore she's a terrorist ka gore ha go tlhoke gore he's a terrorist ha go tlhoke gore a hapela ga le gotle ke di power tse le gore ene o di tshwere ka gore melao e supa gore mo executive le tshwere ba eng so se so no tshwantse le sitse ha e mo minister go go nna le molao wa society so re o ene the registrar o ka go deregister your organization kana o ka gana go register your organization which means ka re BDP tso ga ithuga ka moso go obvious ya ka ke phekya ya tso ga ya go registeriwa and the registrar o go gana ka go gana ne go register and other political parties tse di existant nngwe sentse tle go declare a terrorist organization gona go haka ya contest mo ditlhopong se lo tshwantse lo se itse yana ke gona go rata go lela ga rona. Thank you.
Thank you, lady. Yeah, next round of questions.
The agitation is noted. The ruling party, because of its political advantage, what is different this time around? How much ground have you covered? And for the parliament, are you expecting any support from the ruling party on the backbench? What are their opinions? What are their opinions on this deal?
Thank you. Next question.
Nicholas Botswana questions. Honorable Parliament, Thomas Imusi, has he not briefed Parliament, the General Assembly, that is the participation in Malawi? The other question, Kapinga, the regulatory and accountability framework, the oversight. Do you have trust for executive, especially when security? Do you have trust that they will come up with such, in terms of trying to have the law crafted in a better way? Then, the stages. As an opposition collective, are there any amendments that you are discussing among yourselves that you will want, at that stage, the amendments so that you can put them forward, in trying to help to shape this law into a better law. The time, the time for the population census, the Mola. Towards the end of last year, Assistant Minister Ramtimku, when the delay for starting of the exercise, their population census, it has to do with COVID-related issues. So how we do that then today? Are you saying Ramtimku misled Parliament and the nation? How are the cause for the delay of undertaking of the exercise? That is.
All right, thank you so much. I'll take the last question, if any, before the answer. Right, Honorable Kapinga, would you like to maybe start since the first question was to Parliament?
The first question, if I got it right from 𝐎𝐏𝐻𝐒, is whether we have lobbied. Of course, we talk to our colleagues, if I may label them such, from the other side, who are in the backbench. But my personal experience since I became a legislator is that it is very difficult, very risky to rely on the support of a BDP backbencher. They have let us down on several occasions when we had discussed with them and voted along party lines. So for me, personally, I'm not counting on the support of any BDP legislator. I'm not. If they vote with us, that will be a bonus. But I'm not counting on them. What I'm counting on is the strength and power of the moral position that we have adopted. The moral stand that we stand on is the power, the most potent weapon that we have, which I believe will make this government go back to the drawing boards and come up with some legislation that has a semblance of a constitutional, respect for the rights of the citizen. That's what I'm counting on. And as you know, we don't live in a secluded country. We live in the global world. These matters have come to the attention of other countries, of other organizations that I believe will assist us in exerting pressure on this government to go back and think again about what they want to do. Regulatory mechanisms. Do I have trust that they will come up with any credible mechanism? As I told you, my personal classification of our democracy is that it is a primitive democracy. That our current government does not believe in creating true and real accountability measures and institutions. They don't. They don't like accounting to anybody. Rather, they would like to cultivate and entrench a culture of impunity. So I will only believe when I see. But with their history, I tell you, and I speak, unequivocally, this government does not have the right mindset, does not have the political will to create a culture of accountability in this country. That's my position.
Right, thank you so much. If I get it, then you'll pass by the question now already. Has the Minister brought to the General Assembly about this bill?
No, the Parliament has never been briefed by the Minister. On the issue of COVID related with the census, indeed, Honorable Mthimkhulu last sitting, he said we couldn't go ahead with the population census because we are in the midst of COVID. But who said the COVID has vanished? The COVID is still around, but we are going ahead with the population census. So the justification of we failed to carry on the population census because of COVID. While this time around we are going ahead with the population census while the COVID is still existing. It was a lame excuse, so we cannot count on that. But on the issue of lobby, to address Honorable Kapinga said, the BDP of today is not the BDP of yesterday. I remember one time when we were getting applied a loan for a loan at electrification of 100 villages. One of the BDP members said, no, the minister, I can see a hidden hand of the minister in this loan. So we rejected the loan. It was under Mukhai. Mukhai phoned, he was on air, came from overseas. We waited for him in Parliament. When he arrived around past 7, he pleaded with the Parliament. You know what? We have applied for a loan from Sweden. And these people, we're going to tarnish their name. Can we accept the loan so that the people in our rural area that are waiting for electricity? So the investigation for DCEC, police, they will be there all over to make sure that they're going to dig to make sure that the information is available so that whoever committed the crime is going to face the music. I remember the late Lizo Mumuseno, I do understand what His Excellency is saying, but since the bill has been withdrawn before Parliament, we cannot take it back to Parliament. We have to wait for the next 30 days. And then Remohai said, no, now my hands are tied, there's nothing that I can do. Under Remohai, I'm trying to talk to the issue of lobbying. The committee that was overseeing the privatization of the Air Botswana, it was chaired by Honorable Member of Parliament for Gaborone Central. By then it was Dumelan Salashani. And then they said, no, we cannot take our Air Botswana to a link to South Africa. We want to make sure that we assist the Air Botswana as we can as a government to make sure that our flag is going to fly high. So that bench of BDP and the opposition agree in totality that no, we're going to oppose the privatization of Air Botswana. Because there were people in the mind of the BDP backbench then. But today, it's about Tsogwane, it's about Tsogwane. Tsogwane is the only person who will be debating. The rest of the backbench, they are there to vote. So it is very, very difficult to lobby someone who is relying heavily in his vote. He cannot exchange, assist in a debate anyhow. So it's very, very frustrating. So under Kama, I remember it was the time when we were doing DIS Act. The DIS failed to pass because even the BDP members of Parliament, they were saying, no, we have not yet internalized this, and the people, they don't know what kind of a creature are we coming up with. So we couldn't pass the DIS Act. But at a later stage, yes, the DIS Act managed to pass, even though the opposition we walked out because we didn't want to be associated with a rogue law in the name of DIS. But I'm trying to give you the picture of the BDP of yesterday and the BDP of today. Even yourself, when we go out here, go and talk to the members of Parliament of BDP individually. They will be agree with you to say, no, wait for the vote. Wait for the vote. I thank you, sir.
Thank you. And then maybe as we speak to it, also there's an element of a question, yeah, do you have amendments to put forth?
Oh.
Yeah, I think, yeah, after
No, that one is for MPs.
Yeah.
But I will answer Ray Nicholas's question about whether we trust that there is scope to deal with these oversight mechanisms. add on to what Kapinga is saying. There are constraints in the way, first, our constitutional framework, and two, the already existing laws. If you look, for example, just to give an example, if you look at the DIS, the legislation, in Botswana, the DIS reports to a board that is appointed by head of the executive branch, the president. That means the DIS already is controlled almost entirely by the presidency. In most democratic jurisdictions, the DIS, the oversight is the legislature. So there would be laws that we would need to entangle ourselves from to ensure that the role of Parliament and the role of the judiciary will be more pronounced. That's one. Constraints around the need to untangle ourselves from existing laws. The second is to do with our constitutional dispensation. In more democratic jurisdictions, for example, parliaments or legislatures actually originate laws. In the US, for example, the House of Representatives originates what are called revenue laws, meaning that the budget, the whole budget framework and thinking around the budget originates from the House of Representatives, and the executive catches on later. In Botswana, you know, the Minister of Finance and the executive originates. So there are things that we need to do as a country. We need to fix, reform, restructure our constitution to ensure that we have a foundation where, generally speaking, we have laws that ensure that different branches of government are checking against each other. And the second is already existing laws which entrench the powers of the president or of the executive. So there are challenges there already. But that is not to say that, you know, in life you always make the best out of your circumstances. That is not to say that given the circumstances under which we live, there are certain things, as Honorable Kapinga has said, that we can do to try as much as possible to ensure that the judiciary is involved throughout the stages. And one of the missing links is the lacking role or the lacking involvement of the judiciary. I hope that answers you, Mr. Nicholas.
On the issue of amendments, the amendments are there in the various pieces of legislation before Parliament. But most of the amendments are coming from the opposition. But the law in question that we are dealing with here is not yet, we cannot say the amendment are there because we are still waiting for Remusi to say maybe it will be coming up with a better version of the first reading during the second reading because they put it back yesterday and then we are waiting for him, as he was promising. I keep on telling him that no, when I was in Australia, I said politics, so we say, and they were like, "Give me a hammer, so what kind of happiness is in there?" So really, the amendment, it will be there to be debated by Chopani and be voted out by the backbench.
Right, thank you so much. We have kept here for slightly over an hour. So if there is maybe a last round of any burning questions, I'll take those that we have done. Any further questions? Brilliant. Thank you so much for coming in, and we will keep communicating with you. And we'll fight. It's also your rights at stake. Thank you so much.
Thank you.